And thank you for joining us. I'm Haley. This is Joe, and we are glad to be here this morning to present to you. Hopefully, you can take away some key items from this presentation and implement them in your counties. So whether you're an elected official, a supervisor, a department head, an HR professional, or a county leader, every employment decision you make has the potential to either strengthen or weaken your county's position if it's ever challenged. Today, we're going to do something just a little bit different than normal. Rather than simply walking through policies and legal requirements, we're going to follow the timeline of one employment claim from the very beginning of the employee complaint all the way to the courtroom. As we move through this presentation, I want you to ask yourself one question. Could this have been prevented? Because that's really what today's session is about. Not avoiding accountability and not avoiding difficult conversations or not avoiding discipline. It's all about recognizing the moments where good management and good documentation make all the difference. Today, you'll meet an employee named Sarah. Sarah isn't one specific employee from one specific county. She's a combination of situations we've encountered through actual employment claims over the years. Her story represents the types of issues counties face every single day. As Sarah's story unfolds, Joe and I are going to stop along the way to discuss what happened, what should have happened, and how different decisions could have completely changed the outcome. By the end of today's session, you'll have a roadmap to identifying risk early, responding appropriately, and helping protect both your employees and your county. Joe, before we meet Sarah, why don't you explain why this topic matters from a claims perspective?
Thanks, Haley. One of the things I've learned over the years is that employment lawsuits almost never begin with someone saying, "I'm going to sue you." Instead, they begin with something much smaller, a conversation, a misunderstanding, a complaint that isn't taken seriously, documentation that never gets written down, or a supervisor who honestly believes they're doing something right, but doesn't realize how their actions might be viewed by others months or even years later. By the time our claims team receives a file, we're often looking back at decisions that can't be changed. That's why today's conversation is important. At every stage, we're going to discuss the actions that will put the county in a stronger position or weaken and increase the risks of a claim going forward. Our hope is that you'll leave today seeing employment claims differently, not isolated events, but the result of many decisions over time.
Excellent, Joe. Thank you. Those are great points. At this time, we're going to turn off our camera so you don't have to see our face and you can focus on the presentation, and we'll continue on. Okay, so before we continue into Sarah's story, I want you to take a moment I'm going to take a moment to set these expectations for today's session. The information we're sharing today is intended for educational purposes. Every county, every employee, and every situation is unique, so today's discussion should not be considered legal advice. When you're dealing with an actual employee complaint, investigation, or employment decision, it's important to work closely with your county attorney or legal counsel and HR before taking any action. Our goal isn't to criticize those decisions, it's to learn from them. Because when we can recognize the warning signs early, we have a much better chance of preventing the next claim before it ever reaches the courtroom.
And from the claim side, that's exactly what we hope happens. Sometimes people assume that our job begins when a lawsuit's filed. The truth is, our favorite claims are the ones that never happen. Every investigation that's handled correctly, every supervisor who documents objectively, every phone call asking for guidance before a difficult employment decision. Those are the moments that help counties avoid unnecessary risk. Today's presentation is about identifying those opportunities before they become expensive problems.
So as we move through Sarah's story today, don't focus on whether you would have made the exact same decisions. Instead, ask yourself, what would I have done differently? Because that's where learning happens. At this time, I'm going to pause and give you your first key word, and it is consistency. So before we hear what happened to Sarah after she raised her safety concern, we need to talk about one more thing that can change the rules of the game for some counties. It's collective bargaining agreements. Because if a CBA applies, it affects how complaints, investigations, disciplines, and grievances must be handled. Some counties operate under collective bargaining agreements or CBAs. Others don't. Regardless of whether your county has one, every county has policies, procedures, and employment practices that establish expectations for handling employee issues. If your county is covered by a CBA agreement, it may include additional requirements for investigations, discipline, grievance procedures, timelines, employee representation, and appeals. Those aren't suggestions, they're contractual obligations. Ignoring them can create liability when underlying employment decisions were justified. If your county doesn't have a CBA, don't tune us out just yet. The same principle applies to your personnel policies. If your handbook says you'll investigate complaints, investigate them. If your policy outlines progressive discipline, follow it or document why an expectation was or an exception, was appropriate. Consistency builds credibility.
From the claims perspective, one of the first questions we often ask is surprisingly simple. Did the county follow its own policies? Notice I didn't ask whether the employee was right or whether the supervisor had good intentions. I asked whether the county followed its own established policies. Because once a claim is filed, attorneys can request your policies, your handbook, disciplinary records, investigative files, emails, training records through public information requests or from discovery. If your own documents show that established policies weren't followed, it becomes more difficult to defend those decisions later.
So let's take all of this and apply that to Sarah. At this point in her story, nothing dramatic has happened yet. Sarah has simply reported what she believes is a workplace safety concern. She's expecting her employer to take it seriously. She's trusting that the process outlined in county policy will be followed. She has no idea that over the next several weeks, a series of decisions will completely change the direction of her employment. And that's exactly why we're spending so much time talking about policies right now. Policies don't matter only after something goes wrong. They matter because they guide us before something goes wrong. Now that we understand the framework that governs employment decisions, let's go back to Sarah. She has reported that safety concern. She is expecting someone to listen. Instead, a chain of events begins that eventually leads to an employment claim. So let's walk through the life cycle of a claim and identify the moments where the outcome could still be changed. One of the biggest misconceptions about employment claims is that they happen suddenly. They don't. Claims develop over time. They're built on one decision at a time. Think of an employment claim like a row of dominoes. One decision tips the next, which leads to another and another, until eventually someone is sitting in a deposition or courtroom wondering, how did we get here? The reality is there were usually multiple opportunities to change the outcome long before the attorneys became involved. Today, we're going to walk through that entire life cycle together. You'll see that most claims follow a predictable path. An employee raises a concern, the employer responds, an investigation is or isn't conducted, documentation is created or possibly overlooked, employment decisions are made, the issue escalates, outside agencies become involved, and then, litigation follows. Every stage creates opportunity to either reduce risk or increase it.
From the claims perspective, we almost never receive a file at the beginning of this timeline. Usually by the time we get involved, we could be in the reactive stage versus a proactive stage. For example, an EEOC charge has already been filed. Attorneys are requesting records. Witnesses have been interviewed. Decisions have already been made. Our job becomes defending those decisions. But imagine how much stronger the county's position would have been if we were involved much earlier. That's why today's discussion is focused on prevention, not reaction.
So let's go back to the very beginning and formally meet Sarah. Sarah has worked for the county for 9 years. She's dependable. Her evaluations consistently say things like meets expectations. She's a team player and a positive attitude. She's never been disciplined. She's the kind of employee supervisors appreciate because she simply comes to work and does her job. Then the department hires a new director. He tells the staff he wants to take the department in a different direction. And at first, nothing seems unusual. A few weeks later, Sarah notices a workplace safety issue. She reports it through the proper channels because she believes that's the responsible thing to do. She's not trying to cause problems. She isn't looking for special treatment. She simply believes the issue needs attention. What Sarah doesn't realize is that single conversation is about to become the first domino in a much larger story. Sarah has reported her concern. The county now has the opportunity to demonstrate fairness, professionalism, and consistency. So, what happens next? Let's walk through the most important stage of the entire life cycle of an employment claim, the initial complaint.
A few days after reporting the safety concern, Sarah notices things begin to change. Her supervisor, who used to greet her every morning, barely acknowledges her. She's no longer invited to meetings that she was routinely attending. Projects that she successfully managed for years were reassigned to other employees. Her workload increases, but her opportunities to contribute seem to disappear. At first, Sarah wonders if she's imagining it. Maybe everybody's just busy. Maybe it's a coincidence. But after several weeks, the pattern becomes impossible to ignore. Finally, she walks into HR and says, "Ever since I reported the safety issue, everything has changed. My supervisor barely speaks to me. I'm excluded from meetings. My workload is doubled. And suddenly I'm being treated like I'm the problem." Now, let's stop the story there because this is one of the important moments in the entire life cycle of an employment claim.
Everyone, I'd like you to imagine that you're the HR professional receiving Sarah's complaint. What's your first step? Go ahead and type your answers into the chat. I'm going to pause for a moment, allow 30 to 45 seconds for you guys to tell me what your first step would be if you received Sarah's complaint. Meet with Sarah to learn more. Great job, Caroline. I love it. Exactly. Listen, gather your facts from the employee, notify leadership, ask her why she feels that way. All of these are great. But the biggest thing I was looking for is document the complaint. I want you guys to make sure that we need to document, okay? Every complaint deserves attention. That doesn't mean every complaint is substantiated. It doesn't mean that every complaint results in discipline. It simply means every complaint deserves a fair, timely, and impartial review. One of the quickest ways to lose an employee's trust is to dismiss concerns before gathering the facts. Employees don't expect perfection, they expect to be heard.
From the claims perspective, this is often the least expensive part of the claim. At this stage, no one has filed an EEOC charge, no attorneys are involved, no subpoenas have been issued. The county has still complete control over how it responds. Unfortunately, many files we received months later started with a complaint that wasn't fully addressed. Sometimes the supervisor takes it personally. Sometimes assumptions are made before the facts are gathered. Sometimes no one documents the conversation. These early decisions often become the first questions attorneys ask later.
But let's be clear about something. Receiving a complaint is not evidence that anyone did anything wrong. It's simply a signal that something needs to be reviewed. A good investigation protects everyone involved. It protects the employee who raised the concern. It protects the supervisor if the allegations are unfounded. And it protects the county by demonstrating that concerns are taken seriously and handled consistently. That's why your response in the first few days matters so much. So HR has received Sarah's complaint and begins to look into what happens. The next question becomes, how do you conduct an investigation that's fair, objective, and credible? Because the quality of that investigation may one day be examined by an EEOC investigator, an attorney, or even worse, a jury. Let's talk about what happened in Sarah's case. Sarah made her complaint. HR's next responsibility is one of the most important steps in the entire process, conducting a prompt, fair, and impartial investigation. Notice I didn't say quick, I said prompt. There is a big difference. A prompt investigation doesn't mean rushing to judgment. It means responding without unnecessary delay while taking the time to gather the facts. A good investigation should answer one question: what actually happened? When we're investigating, the question should not be, who do I believe? Who's been at the county longer? Who's the better employee? The question that needs to be answered is, what happened? That means gathering information before drawing your conclusions. Typically, an investigation includes interviewing the complainant, interviewing the accused employee, speaking with witnesses, reviewing emails, text messages, policies, schedules, or any other relevant documents. We're looking for facts to support or contradict the allegations. And throughout the entire process, the investigation must remain impartial. Our role isn't to prove someone right, it's to discover the truth. So let's see what happened in Sarah's case. HR meets with Sarah. She calmly explains the timeline. She provides examples of meetings she's no longer invited to. She identifies projects that were reassigned. She describes changes and how her supervisor communicates with her after she reported the safety concern. Next, HR interviews and gets a completely different story. His response: she's just difficult. So let's pause there. That's a conclusion. That's not evidence. So HR then asks a follow-up question. Well, can you help me understand what behaviors you're referring to? And that supervisor then goes, well, everyone knows she's a problem. Again, that's an opinion. That's not documentation. So again, I'm going to ask you one more question. Have you ever had a supervisor say something to you like, everyone knows they're a poor performer? I've heard it more times than I can count. But here's my follow-up question. Was it documented? If the answer is, well, everyone knows, that's usually the biggest red flag, because juries don't hear hallway conversations. Investigators don't review assumptions. They review the evidence. And with that, I'm going to pause and give your next keyword: documentation.
And that's exactly where documentation starts to become critical. When we review a claim, we're looking for objective information. Show us the coaching, show us the performance discussions, show us the written expectations, show us the emails, show us the timeline. If the only explanation is trust us, that's a difficult position to defend. A jury doesn't know your supervisor, they only know what's in the file.
Another mistake we sometimes see is confirmation bias. That's when someone decides what they think happened before they gather all of their facts. Instead of asking what happened, they begin with, how do I prove I'm right? That's not an investigation, that's simply an argument. And good investigators stay curious. They ask open-ended questions, they listen more than they speak, and they allow the evidence, not assumptions, to guide the outcome.
Now, at this point, Sarah's complaint has been received. The investigation is underway. Now comes another critical question. How did you document what you're finding out, what you're learning? Because documentation isn't just paperwork, it's the record that tells the story of your decision making. And as we're about to see, Sarah's documentation tells a very different story than the supervisor intended.
So before we continue with Sarah's story, let's discuss the different types of escalation: internal, administrative filings, and formal litigation. So internal is your complaint that we talked about earlier, going to the HR office, possibly looking at your county policy. Maybe your complaints are meant to go into your county judge or your county attorney. Knowing those are important. Next is your administrative filings. It could be the EEOC charges that we may see, and then of course the formal litigation. So now let's continue with Sarah's story. HR completes the initial reviews and begins reviewing her personnel file. At first glance, everything looks exactly as you would expect: a long-term employee with a strong work history, performance evaluations from the last 8 years are consistent, describing her as she meets expectations. She's a team player. She's dependable. She has a positive attitude, very strong communicator. There are no written warnings in there, no coaching notes, no performance improvement plans, no documented concerns about attitude or performance. And then something changes. Just 1 month after Sarah reports the safety concern, her documentation suddenly looks completely different. Now her evaluations describe her as difficult, negative, resistant to change, poor attitude. So let me ask you a question. Did Sarah suddenly become a different employee overnight? Or did the documentation subtly change? That's a question an investigator and maybe eventually a jury will ask too. So again, I'm going to ask you to participate and type in the chat box. Imagine you're serving on a jury. You receive two pieces of evidence. Exhibit A, 8 consecutive years of positive evaluations, and Exhibit B, one negative evaluation completed immediately after the employee files a claim. Which would raise more questions for you? Exhibit A, good employee, 8 consecutive years of positive evaluations, or Exhibit B, one negative evaluation completed immediately after the employee files a complaint? I'm seeing lots of B's. I love to see that. Great. We learned something, right? Exhibit B. That is exactly why when we talk about documentation, timing matters, because the perception of what we are seeing in Exhibit A and Exhibit B matters completely in a claims perspective. So that doesn't mean necessarily that the supervisor's concerns aren't legitimate if it truly is a different type of employee that we are now seeing, there's something has changed in her. It means the supervisor now has the burden of showing those concerns existed before the complaint or explaining why they developed afterward with objective evidence. That's why documentation must be ongoing, not created after the problem arises.
This is one of the first things we look at when evaluating an employment claim. We're asking, is the documentation consistent with the employment decision? If the termination is based on poor performance, we expect to see documentation showing a pattern of performance issues. If it's based on misconduct, we expect to see records describing the specific behavior, when it occurred, and how the employee was made aware of these expectations. When those records exist, it gives us an objective case to defend. When they don't, well, we're often left trying to explain a decision that isn't supported by the file. And that's not the position you want to be in.
So let's talk about another important concept, progressive discipline. Many county policies include some form of progressive discipline, not because every situation requires each step, but because employees should generally have an opportunity to understand expectations and correct behavior before a more serious action is taken. And in Sarah's case, here's what happened. The supervisor, he skipped the coaching, skipped verbal counseling, skipped written warnings, skipped performance improvement plans, and instead was told, Sarah, she just has a poor attitude. So let's think about that for a moment. How do you measure attitude? Can two supervisors have different opinions about someone's attitude? Absolutely. That's why documentation should focus on observable behaviors and not conclusions. Instead of writing Sarah has a poor attitude, a stronger example might be on 3 occasions during staff meetings, Sarah interrupted coworkers after being asked to allow others to finish speaking. Coaching was provided after each incident. You see the difference? One is an opinion, and the other describes the behavior. Behaviors can be observed, behaviors can be documented, and behaviors can be addressed. I'd like you to think about a phrase you've heard, or maybe even written in documentation. The poor attitude, not a team player, negative. Now, I want you to internally ask yourself, could someone outside your organization read that and know exactly what happened? If the answer is no, you probably need to go into more detail.
One phrase we hear fairly often is, everybody knows they're difficult. And my response is always the same. Show me the documentation. Because if it isn't documented, it becomes very difficult to explain why the employee decision was made. Documentation isn't about creating a paper trail against employees. It's about creating a clear record of expectations, communication, and opportunities to improve.
At this point, Sarah's relationship with her supervisor has continued to deteriorate. Soon afterwards, she's terminated. Feeling that Sarah wasn't treated fairly and believing her complaint played a role in what happened next, Sarah decides to take the next step. And from that moment on, the county is no longer managing an employee issue, it's managing a legal claim. Joe, this is where your team shines and often becomes involved. Let's talk about what happens next.
This is typically the point where our team receives the first phone call. Someone says, "We've received an EEOC charge. What do we do now?" That's an important reminder. We'd much rather receive a call before the termination than after the EEOC charge arrives, because once it's filed, the focus shifts. Instead of asking, "What's the best employment decision?" we're asking, "Can we explain and support the decision that was made?" Two very different conclusions. I do want to point out that at this stage, there's a settlement opportunity at the front end of when an EEOC charge is filed. The EEOC offers a free mediation service. If both sides agree to go, uh, you can see if something can be worked out and resolve the claim at that stage. The advantages are if you agree to go to the mediation, you don't have to respond to the charge until after the mediation and there's no settlement. The disadvantage is you have to be willing to offer some money. So we don't always use the service, but it's something we always consider. So that's a settlement opportunity at the kind of the front end of the claim that it's something always worth considering.
Very good information, Joe. I want you all to notice something. Nothing new happened after Sarah was terminated. The facts didn't change, the investigation that the county conducted didn't change, and their documentation surely shouldn't change. The only thing that changed was who was reviewing those county actions. And that's why we have spent so much time this morning talking about documentation, investigations, and consistency. By the time an outside agency becomes involved, you usually do not get to create new evidence. You're relying on the work that was or wasn't done at the very beginning.
One of the biggest surprises for supervisors is realizing how much information may be reviewed during a claim. It's not just the termination letter. It's the emails, the calendar entries, investigation notes, performance evaluations, training records, policies, sometimes even text messages if they relate to the employment decision. That's why professionalism and consistency matter long before anyone mentions the word lawsuit. So now Sarah has filed her EEOC charge. The county has responded. What can we expect to happen next? The EEOC will evaluate the charge and respond and determine if they need to do any further investigation. Most of the time, the EEOC will not go any further with the investigation and simply issue a right to sue letter. Once the right to sue letter is issued, the claimant has a limited amount of time to file a civil lawsuit and seek damages against the employer. If a lawsuit is filed, the next phase is one that many supervisors never expect to experience: discovery. This is where every email, every note, every inconsistency may become evidence. Let's take a look at what that process looks like and why good risk management starts before litigation ever begins. Discovery is exactly what it sounds like. Both sides exchange information. Both sides begin gathering evidence. And this is when supervisors often realize just how much information has become part of the case.
Sorry about that. We had a little technical difficulty on that.
During the discovery, attorneys may request personnel files, performance evaluations, investigation notes, disciplinary records, emails, texts, messages, policies, training records, personnel records, supervisor notes, calendar entries, witness statements. Almost everything connected to the employment decision potentially subject to review. Notice something. None of these documents are created during discovery. They're created months or sometimes even years before the discovery begins. That's why good documentation is always about preparing for litigation, or isn't about preparing for litigation. It's about managing employees consistently every day.
So, from an HR perspective, discovery can either validate your processes or expose its weaknesses. Let's think back to Sarah. When HR opens her personnel file, they find 8 years of positive evaluations, no coaching documentations, no written warnings, no performance improvement plans. Then suddenly she reports a safety concern. The documentation changes dramatically. And imagine you're that attorney reviewing that timeline for the very first time. What questions would you ask? You'd probably wondered, well, what changed? Why now? Why is there documentation supporting these concerns before the complaint? Those are exactly the same questions investigators and juries may ask.
One of the most uncomfortable moments in discovery is when an attorney asks a supervisor a simple question. Can you show me where you documented these concerns? Sometimes the answer is immediate. Sometimes it's right here. But sometimes the answer is silence, or worse, I didn't think I needed to write it down. That one sentence has made defending these cases significantly more difficult. Documentation doesn't guarantee you'll win, but the absence of documentation makes your job and ours much harder.
Another thing that we often like to remind our supervisors and elected officials is this. Don't create documentation with the expectation that no one else will ever read it. Write every email, every investigation note, every coaching record, every performance evaluation as though someone outside your organization may eventually review it, because someday they might. Professional, objective, and factual. Those three words should guide every piece of documentation that you create. My favorite saying is separating your facts from your emotions, right? So I used to tell people that all the time when they were doing documentation. And with that, I'm going to give you your next word, attitude.
So once written discovery is completed, the next phase becomes more personal. Now people are no longer just writing documents, they're answering questions under oath. Sarah's supervisor, HR, department leadership, everyone involved in the employment decision may be asked to explain what happened. Let's talk about depositions and why consistency matters just as much as documentation. Written discovery is concluded. The documents have been exchanged. The personnel file has been reviewed. Now comes the phase that many supervisors never expect to experience, the deposition. For anyone who hasn't participated in one before, a deposition is sworn testimony taken before trial. Attorneys ask questions. A court reporter records every answer. Those answers can later be used in court. The purpose isn't to argue the case. The purpose is to learn exactly what each person remembers, why decisions were made, and whether everyone's testimony is consistent with the documentation. Now let's go back to Sarah's case. Several people are deposed. Sarah, her supervisor, the HR representative, the department director. Each person is asked the same basic question. Why was Sarah terminated? It seems like a simple question, but watch what happens. Sarah says, I believe I was terminated because I reported a safety concern. Supervisor says, she's got a poor attitude. HR says, we relied on the supervisor's recommendation. The department director says, I understood it was a performance issue. Now imagine you're sitting in a jury. Who's right? More importantly, which version is supported by the documentation? Because that's the version people will most likely believe.
This is why HR spends so much time emphasizing consistency. It's not because we expect everyone to remember every conversation exactly the same. That's unrealistic. People remember events differently, but the documentation should help everyone understand what happened, when it happened, what expectations were communicated, what actions were taken, and why the final decision was made. Good documentation creates a common understanding. Poor documentation leaves everyone relying on memory, and memory fades.
One of the most difficult moments in a deposition is when an attorney places a performance evaluation in front of a supervisor and asks, "Can you help me understand why this evaluation says Sarah exceeded expectations in March, but by April she suddenly had a poor attitude?" If the supervisor can point to documentation, documented coaching, objective performance concerns, and consistent communication, it's a much easier conversation. If they can't, the attorney is going to keep asking questions. And remember, attorneys aren't just looking for answers, they're looking for inconsistencies.
Consistency, it doesn't necessarily mean that every manager has to use the exact same word. It's not coaching them to all say the same thing. It means everyone should be able to explain the decision using the same facts. That's one reason why HR should be involved before significant employment decisions are made. Sometimes we ask questions as HR that help identify gaps before someone else does. Because remember, the file you create becomes the story you have to tell.
So, if a case isn't resolved after the deposition phase, the next step would be the courtroom. That's where everything we've talked about comes together. Not because a jury is deciding whether Sarah was a perfect employee, but because they're dealing with whether the county acted fairly, consistently, and within the law. Let's step into the courtroom for a moment. Everyone we've taught, Everything we've taught, policies, investigations, documentation, progressive discipline, the EEOC, discovery, and depositions has been leading to this moment. Here's the key message I want to leave the audience with. The courtroom doesn't create the problem, it simply exposes the process. Now that we've reached the stage where everyone hopes to avoid the courtroom, when people picture a lawsuit, they often imagine a dramatic testimony, surprise witnesses, or heated arguments like you see on TV. The reality is usually much different. Employment cases are often won or lost long before anyone enters the courtroom. By the time the jury hears the case, they're reviewing decisions that were made months or even years earlier.
So let's think back through Sarah's story. She's reported that safety concern. She's noticing changes of how she was treated. She filed a complaint. The investigation revealed very little objective documentation supporting the supervisor's concerns. Her performance evaluations changed dramatically after the complaint. Progressive discipline was not followed. The reasons for her termination weren't consistently explained. Now imagine you're one of 12 jurors hearing this case. You don't know Sarah. You've never met her supervisor. You don't really know anyone involved. All you know is what you've heard in the courtroom and what you see in the evidence before you. Based on what we've learned so far, what questions would you have? Most people would have a ton.
The jury doesn't care, it doesn't create new evidence. The jury doesn't rewrite the policies. The attorney doesn't change your documentation. They simply present what already exists. If your investigation is thorough, if your documentation was objective, if your policies were followed consistently, those decisions become stronger defense. If they weren't, the courtroom will simply make those weaknesses more visible.
One of the biggest misconceptions in employment law is that good documentation guarantees you'll win. And that's just not true. There are no guarantees, but good documentation gives the county credibility, and credibility matters. Jurors are constantly asking themselves questions like, did the leadership listen? Did HR actually investigate? Were their own policies followed? Was the employee treated consistently? Was that decision based on supported facts? When the answer to these questions are yes, the county is in a much stronger position.
And remember, the goal isn't to create documentation because you're expecting to be sued. The goal is to make sound employment decisions that you can confidently explain if they're ever questioned. Good management and good risk management usually looks exactly the same.
Sarah's case has illustrated something very important. If the county believed it made the right decisions, the process left unanswered questions, and unanswered questions create risk. So before we wrap up today's talk, let's talk about the cost of those decisions, and then more importantly, how counties can prevent situations like Sarah's from happening in the first place. So taking that last look at Sarah's story, by the time her case reached the courtroom, the county had already investigated and invested so much time and amount of resources. Think about everyone who became involved, your HR, the supervisors, departmental leadership, county officials, the claims team here at TAC, maybe your HR consultants, outside legal counsel, witnesses, administration staff. Countless hours were spent gathering records, responding to requests, preparing for interviews, and participating in the legal process. Even if the county ultimately prevails, that's time that could have been spent serving employees and the community. Employment claims don't just cost money, they cost time. They affect morale. They create stress for supervisors, HR professionals, coworkers, and your elected officials. The best outcome is preventing the claim from reaching this point in the first place.
One of the questions we're often asked is, what could we have done differently? When we look back at cases like Sarah's, the answer is usually not one dramatic change. It's several small decisions that are consistently over time. If we rewind Sarah's story, imagine this instead. Sarah reports a safety concern. The supervisor thanks her for bringing it forward. HR is notified immediately, and an impartial investigation begins. Concerns about Sarah's performance, if they truly exist, are documented as they occur with coaching and clear expectations. Policies are followed consistently. Before any significant employment decision is made, HR, leadership, and legal has an opportunity to discuss the facts. Now ask yourself, does the outcome necessarily change? Maybe, maybe not. Sarah may still be disciplined. She may still be terminated if there's a legitimate, well-documented cause. But one thing changes dramatically. The county has a process it can confidently explain and defend. That's what good risk management looks like.
Notice something about everything we just described. None of it required an expensive software. None of it required a larger budget or a whole team of attorneys. It required good leadership. Let's look at the moments where Sarah's claim could have been prevented. A supervisor who responded professionally to a workplace concern. Early involvement from HR. A prompt, impartial investigation. Objective, behavior-based documentation. Consistent application of all county policies. Coaching and communication before discipline whenever appropriate. An early consultation with the claims team, your HR consultant here at TAC, or your legal counsel before any high-risk employment decisions are made. Those aren't complicated ideas, but if they're applied consistently, they dramatically reduce the county risk. The lesson isn't that Sarah could never be terminated. The lesson is the process matters just as much as the decision. A fair, consistent, and well-documented process protects the county, supports supervisors, and builds trust with employees. We've spent the last 45 minutes or so following one employee's story from a simple workplace concern to the courtroom. Before we wrap up, we'd like to hear from you. Looking back at Sarah's story, where do you think the claim truly went off the rails? There isn't just one right answer. In reality, claims like Sarah's rarely result from a single bad decision. They're usually the result of several missed opportunities that build on one another. So go ahead, type your thoughts into the chat and let me know where you think it went off the rails. Lack of documentation. I love that you said that, Krista. That is amazing. That's what we want you to hear. Documentation, documentation, documentation.
Another documentation.
Lack of documentation and discussions. No documentation. Very good, guys. Those are great observations. Some of us focus on the discussions and the investigations. Some of us focus on whether communication was happening. That's exactly why employment claims are so complex. They rarely are caused by that one issue. They're usually caused by several issues happening at the same time.
When we review employment claims, we often see the same themes repeated, not because counties don't care, but because supervisors are making difficult decisions while balancing competing priorities. Looking at Sarah's case, here are the areas that stand out to us. The complaint wasn't handled with a documented impartial process. Performance concerns weren't supported by consistent documentation. The timing of the negative evaluations raised questions. That's a big one. Performance discipline wasn't followed, or excuse me, progressive discipline wasn't followed or explained. HR wasn't fully integrated into the decision making. The reasons for termination weren't consistently communicated. Notice something. None of these issues about whether Sarah was a good employee. It's about whether the process inspires confidence.
And that's the lesson we hope everyone takes away from today. Good employment decisions don't just happen by accident. They're built on preparation, they're built on communication and consistency. When supervisors, HR, elected officials work together, difficult employment decisions become much easier to support. One of the themes you've heard throughout today's presentation is that no one should have to navigate these situations alone. Counties have resources available before, during, and after challenging employment situations. So let's spend a few minutes talking about your HR consulting team who partner with counties to help prevent claims before they happen, right? So you have myself, I'm in the Northeast. You have Sharon Blankenship. She is newer to the Southeast, but not new to TAC. And then you have Jen, who has taken on the Southwest region, and Rita Fife in the Northwest. Throughout today's presentation, we've followed Sarah's story from the very first complaint all the way through litigation. One thing I'd like for you to notice is that there were multiple opportunities where someone could have picked up the phone and asked for guidance. Your TAC HR resource, HR consultants are here and available for any technical questions for you to answer. Not because the county had done something wrong, right? But because we want to make sure that we are handling a difficult situation appropriately. We're not here only when something goes wrong. We're here to help counties make good decisions before those decisions are ever questioned. Every day we work with counties across Texas on issues like employee investigations, performance management, documentation, ADA accommodations, FMLA administration, harassment and discrimination concerns, and the list could go on all day long. Sometimes it's a 5-minute phone call. Sometimes it's helping review their documentation. Sometimes it's providing supervisor training before a pattern becomes a problem. Our goal is always the same: help counties reduce risk while treating employees fairly and consistently.
And from a claims perspective, I can tell you those early conversations make a tremendous difference. When HR reaches out before a difficult employment action, when supervisors ask questions before making a termination decision, when counties involve the right people early, the outcome is often much better. Sometimes the advice is, you're on the right track, keep documenting. Sometimes it's, let's slow down a minute here and gather a little more information before moving forward. Neither answer delays good management, it just strengthens it.
One thing I hope today's presentation reinforces is that asking for help is a good sign of leadership, not uncertainty. Employment laws are complex. People are complex. Every situation is a little different. None of us should expect supervisors to have every answer. That's why partnership matters. HR, leadership, your claims team, legal counsel, elected officials. When all of those groups communicate early, counties make stronger decisions and employees gain confidence in the process.
And remember, you don't have to wait until an EEOC charge arrives. You don't have to wait until an attorney sends a letter. You don't have to wait until someone says the word lawsuit. The earlier the conversation happens, the more options everyone has.
So we've talked a little bit about what the HR role is and introduced you to the team here. Let's talk about our claims team.
Throughout today's presentation, you've heard us say several times, um, timing matters. This only applies to, not only applies to documentation investigation, it also applies when you involve your claims team. One of the most common phone calls we receive is, Joe, I wish we'd have called you sooner. By the time that call comes in, an employee has often been terminated. EEOC charge has been filed. An attorney may already be involved. At that point, we're focused on helping the county respond to the decisions that have already been made. And we're always ready to help, but we'd much rather be part of the conversation before those decisions are made. Early reporting doesn't mean you're doing something wrong. In fact, it's a sign you're doing exactly what good leaders do. You're recognizing that situations carry risk, that seeing a guidance before moving forward. Sometimes the advice is simple. Your documentation looks good. Continue with following your process. Other times we may identify issues that deserve another look before a final decision is made. Either way, the conversation strengthened the county's position. Here's the claims team up on the screen. I'm in the Southeast region. Misty Paul is Northeast. Kendra is new to our group. She's not new to TAC, but she's new to our group. She's in the Northwest, and Mary Brasino's in the Southwest. So our contact information is there if you ever need to reach us.
So one of the biggest lessons from Sarah's story is that no one person should be carrying the weight of these decisions alone. Supervisors bring operational knowledge. HR brings that expertise in employment practices and policy. Legal counsel provides advice on applicable legal issues. The claims team brings the experience from seeing how similar situations have played out across many counties in Texas. When those perspectives come together, counties make stronger, more consistent decisions. And at this time, we will open up for any questions.
Haley, Joe, there was one question in the chat. It was asking, how is EEOC involved when termination was not based on Title VII issue?
Well, we designed this to just be a generic claim. It could have been, we could have picked, a discrimination type of thing on race or gender or something like that. But we just chose to do this one based on her reporting something. The EEOC, they can still report this kind of thing, the EEOC.
That's what's important about understanding what can go to the EEOC. So anybody can report to the EEOC.
Anything.
And it doesn't necessarily just have to be from Title VII. It could be age discrimination. It could be religion complaints, accommodation complaints. All of these things play a factor in this. So I think it's important to understand that it's not just Title VII.
And by the way, I've never seen the EEOC say, no, you're not getting a right to sue letter. They always do. So,
and in y'all's example with Sarah, probably would have been based more on retaliation,
right?
Correct? And then she maybe could have tacked on a Title VII claim or an age claim or disability claim on top of that.
Because of the retaliation that happened after the complaint.
right.
Awesome. Are there any, I don't see any other questions in the chat. If y'all have any questions, you can type them in the chat and we will answer them. That's the only one I saw.
Okay, awesome. If there are no more questions in the chat and you don't have anything, we appreciate you spending some time with us today. And if you have any other questions or need to reach out to us, don't feel like you can't. We're here. Thank you, guys.
Thanks, everybody that attended. Appreciate you.